ating unang speaker, nais namin ipahatid sa mga tagapakinig natin na ang unang tatalakayin natin sa usapang batas ay usapang batas sibil at marital. Meron po tayong tatlong speaker sa paksa na ito at ang unang speaker ay si Attorney Crisel Bauto Hipolito Aguilar. Siya po ay isa sa mga direktor ng Integrated Bar of the Philippines, Nueva Ecija Chapter. At partner din po siya, isa siyang practicing lawyer at partner sa Bauto Hipolito Law Offices. Let's all welcome Attorney Crisel Bauto Hipolito Aguilar. Attorney Crisel.
Thank you very much po, Attorney Mau and Ala Jobo. We'll start the discussion po. And as earlier mentioned, I will be discussing po the first part, which will be dealing with persons' family relations. I will be sharing now po the slides that we have prepared. Pag-usapan po natin ang may kinalaman sa annulment of marriage. Una po, what is marriage? By definition of law, ito po ay matatagpuan sa Family Code na ang sinasabi po ay marriage is a special contract of permanent union between a man and a woman entered into in accordance with law for the establishment of conjugal and family life. Ang pag-aasawa po sa ilalim ng batas ng Pilipinas ay nasasaklaw at ginugobyerno ng mga batas na tinatadhana natin sa ilalim ng Republika ng Pilipinas. Ngayon po ay sino po ba ang pinapayagan na makapag-asawa sa ilalim ng batas sa Pilipinas? Una po, a man and a woman. Hindi pa po pinapayagan sa batas ng Pilipinas yung tinatawag po na same-sex marriage na meron na po sa ibang bansa. Pangalawa po na requirement, kailangan po ang gulang ay 18 years old pataas. 18 to 20, nangangailangan po ng additional requirement na parental consent. Samantalang kung 21 to 25 po ay nangangailangan naman ng additional requirement na tinatawag na parental advice. Bawat partido po, ang babae at ang lalaki ay dapat of sound mind. Ibig sabihin ay kailangan po na nasa wasto ang pag-iisip at panghuli, kailangan po ay consent na dapat ay ibinigay ng malaya at hindi pinilit ng sinuman para magpakasal. Is a marriage celebrated abroad deemed binding, valid here in the Philippines and vice versa? As a general rule po, ang isang kasal na isinagawa sa ibang bansa ay valid po sa Pilipinas. Ang requirement lamang po ay kailangan nasunod din kung ano yung mga batas na itinatadhana doon sa bansang iyon kung saan isinelebrate ang marriage. So ang sabi po sa batas, marriages involving Filipino citizens celebrated abroad is valid in the Philippines provided that it is also valid in the place or country where the marriage is celebrated. Gayunpaman, meron pa rin pong tinatawag na exception dito. Ang isa pong exception ay kapag ang isa o pareho sa partido na magpapakasal ay Pilipino at nagpakasal sila na ang edad nila ay below 18. Ang isang halimbawa po dito ay sa Canada. Sa Canada po, inaalaw ang pagpapakasal ng 16 years old, basta po merong consent na ibinigay ang magulang. Ngayon po, kapag ang dalawang Pilipino o isang Pilipino ay pumunta sa Canada para magpakasal at siya ay 16 years old lamang, kahit po allowed yon sa Canada, hindi po kikilalanin sa Pilipinas na valid ang kasal na iyon. Dahil yun po ay isa sa mga exception doon sa validity ng marriage na nire-recognize sa ilalim ng batas ng Pilipinas. What is the difference between annulment or declaration of absolute nullity of marriage and legal separation? Para sa kaalaman po ng lahat, ang annulment po ay iba doon sa tinatawag na declaration of absolute nullity of marriage. Magkaibang proseso po. Pero for the sake of our discussion po, ay tatawagin na lamang po natin ito na annulment. Declaration of absolute nullity of marriage or annulment can be brought before the courts at any time, and this action does not prescribe or it does not expire, while the action for legal separation must be filed within 5 years from the time of the occurrence of the cause, otherwise it will be deemed prescribed according to Article 57 of the Family Code. Ang action po ng Declaration of Absolute Nullity of Marriage or annulment, ang malaking pagkakaiba po niyan sa legal separation ay maaaring dalhin sa korte itong petition for declaration of absolute nullity of marriage kahit po lumipas na ang mahabang panahon o marami pang taon matapos ang pagpapakasal. Hindi po ito na-expire o sa legal term na pe-prescribe. Ang kaibahan po nito sa legal separation ay ang legal separation kailangan po ma-file na sa korte 5 years from the time of occurrence of the cause. Ibig pong sabihin ay magbibilang tayo ng 5 taon mula doon sa paglitaw ng ground para sa legal separation at mula sa 5 taon, sa loob ng 5 taon na yon ay kailangan madala yung action sa korte kung hindi po ito ay mape-prescribe o hindi na po maaaring i-file sa korte. Yan po ang isang malaking pagkakaiba. Ang isa pa pong malaking pagkakaiba ay tungkol sa remarriage. Ang sabi po sa batas, remarriage of either parties is allowed when the marriage is declared ab initio in an action for declaration of absolute nullity of marriage, while in legal separation, the marriage between the parties remain valid and they are not allowed to remarry. Of marriage at yan po ay natapos na sa korte at nagrant, maaari na pong mag-asawa ang babae at lalaki sa iba. Sila po ay binibigyan na ng karapatan na makapag-asawang muli. Sa legal separation po ay hindi po yon pinapayagan. Nananatili po kasi na valid na kahit na sila ay nag-file pa ng legal separation. Ibig pong sabihin ay hindi sila maaaring magpakasal. Ang pinapayagan lamang po ng batas na gawin nila sa legal separation ay maghiwalay at i-distribute na or paghatian ang kanilang mga properties. What are the legal grounds for legal separation? Ito po yung nabanggit kanina na kailangan within 5 years ay maidala na po sa korte para ito po ay mag-grant. Ano-ano po ang mga grounds? 10 lamang po. At kapag wala dito ay hindi po maaaring gamitin na ground for legal separation. Una po ay repeated physical violence. Maaaring paulit-ulit na sinasaktan yung mismong petitioner o yung magfa-file for legal separation o maaaring ang paulit-ulit na sinasaktan ay yung kanilang anak. Physical violence or moral pressure to compel the petitioner to change religious or political affiliation, pamimilit na magpalit ka ng relihiyon ay maaari pong ground para sa legal separation. Pangatlo, attempt of respondent to corrupt or induce the petitioner or a common child of the petitioner to engage in prostitution or connivance in such corruption or inducement. Final judgment po, sentencing the respondent to imprisonment of more than 6 years even if pardon. Kapag po nasintensyahan ang respondent o ang isa sa mag-asawa ng na makulong ng 6 na taon at higit pa, yan po ay ground for legal separation. Lesbianism or homosexuality na hindi po or ikinubli, itinago bago magpakasal, contracting by the respondent of a subsequent bigamous marriage, kahit po ang pangalawa o pangalawang pagpapakasal o higit pa ay ginawa sa Pilipinas o sa abroad, yan po ay ground for legal separation. Sexual infidelity or perversion, attempt by the respondent against the life of the petitioner, pinagtangkaan na po ang buhay ng kanyang asawa, maaari pong ground for legal separation. At panghuli po ay abandonment. Umalis po ng bahay na hindi sinabi, walang makatwirang dahilan, ng higit pa sa 1 taon, yan po ay abandonment at maaaring gamiting ground for legal separation. Sa pagdating naman po sa Declaration of Absolute Nullity of Marriage, yung hindi po na-expire o na-prescribe at maaaring mag-asawa ulit ang babae at lalaki na nagpakasal, isa lamang po ang ground. Ito po yung tinatawag na psychological incapacity of one or both of the parties. Maaaring yung babae lamang o maaaring yung lalaki lamang o maaaring silang dalawa. Sa pinaka-recent po na case na dineside ng Supreme Court, Tal-Andal versus Andal, pinaliwanag po kung ano ang ibig sabihin ng psychological incapacity upang mawala po yung common na paniniwala na ito ay sakit sa isip. Hindi po. Ito po ay hindi medical condition, but ito po ay isang legal concept. Ibig sabihin po ay hindi na ito kailangan na ideklara pa ng isang psychologist o ng isang psychiatrist sapagkat ito ay tinatawag na nga po na legal concept. It refers to a personal condition that prevents a spouse to comply with fundamental marital obligations only in relation to a specific partner that may exist at the time of the marriage but may have revealed through behavior subsequent to the ceremonies. At hindi na po kailangan na kumonsulta pa ng psychologist o psychiatrist para ito ay mapatunayan. Ngunit hihingin po ng korte yung tinatawag na clear and convincing evidence to cause the declaration of nullity of marriage. That concludes po my part for the discussion. Thank you very much po, Attorney Mau and Ala Jobo.
Maraming salamat sa iyo, Attorney Crisel, sa very informative na lecture patungkol sa annulment and legal separation. Ang ating susunod naman na speaker ay si Attorney Ethel Catherine Jean Hernel Angeles. Isa din po siya sa mga direktor ng Integrated Bar of the Philippines, Nueva Ecija. At partner ng Castro Pataxil Arceo Angeles de Leon Matias Villanueva Granado Law Offices. Let's all welcome Attorney Ethel Catherine Joy Hernal Angeles.
Magandang umaga po sa ating mga kababayan dyan sa UAE at magandang hapon naman po dito sa atin sa Pinas. Ang naitalaga po sa akin ay ang adoption at ang support. Simulan ko na po. So ano po ba ang adoption? Adoption is the process of making a child, whether related or not, to the adopter, possess in general the rights accorded to a legitimate child. Meron pong preferences of adoption. Adoption by the extended family, domestic adoption under RA 8552, intercountry adoption under RA 8043. Ano po ba ang domestic adoption or ang tinatawag na local adoption? It applies to adoption of Filipino children, where the entire adoption process beginning from the filing of the petition up to the issuance of adoption decree takes place in the Philippines. When allowed, adoption need not be a last resort. Who may adopt? Sino-sino ba po ba ang pwedeng mag-adopt? Filipino citizen, he must be of legal age, in possession of full civil capacity and legal rights, of good moral character. He has not been convicted of any crime involving moral turpitude, emotionally and psychologically capable of caring for children, in a position to support and care for his legitimate and illegitimate children, at least 16 years older than the person to be adopted. Alien, ay maaari din po silang mag-adopt as long as po yung qualifications as above stated for Filipino nationals ay meron din po sila. His or her country has this diplomatic relation with the Philippines. He or she has been living in the Philippines for at least 3 continuous years. He has been certified by his or her diplomatic or consular office or of any government agency that he or she has a legal capacity to adopt. His or her government allows the adoptee to enter his or her country as his or her adopted son or daughter. Guardians din po ay pwede with respect to the ward after the termination of the guardianship. And pwede din po ang husband and wife. The general rule po, husband and wife shall jointly adopt. Exceptions. Una po, one spouse seeks to adopt the legitimate son or daughter of the other. One spouse seeks to adopt his or her own illegitimate son or daughter. And the spouses are legally separated from each other. Who may adopt? Sino-sino po ba ang pwedeng i-adopt? Any person below 18 years of age who has been administratively or judicially declared available for adoption. Under RA 9523, a child which can be certified as legally available for adoption includes a person below 18 years of age or a person over 18 years of age, but is unable to fully take care of him or herself or protect him or herself from abuse, neglect, cruelty, exploitation, or discrimination because of physical or mental disability or condition. The third one po, illegitimate son or daughter by a qualified adopter to improve his or her status to that of legitimacy. Legitimate son or daughter of one spouse by the other spouse. Person of legal age if prior to the adoption, said person has been consistently considered and treated by the adopter as his or her own child since minority. Child whose adoption has been previously rescinded. Ano po yung mga usual tanong po tungkol sa adoption? Ano-ano po yung mga ito? Question po, how can I adopt? Pwede po tayong mag-coordinate with the Department of Social Welfare and Development or DSWD or any accredited child-placing agency. Sila na din po ang mag-a-assist sa atin at magsasabi ng mga documentary requirements. How long the adoption process takes place? The process usually takes place about 8 to 12 months. Pero po pwede siyang ma-delay, depende po sa pag mga complex cases. And saka po ngayon sa pandemic din po. When do I involve a lawyer in the process? So mag-involve po tayo ng lawyer during the judicial phase of the process. So from the start of filing of the petition until po dun po sa family court. Can we adopt more than child? Yes po, pwede po. Mas gusto po ng DSWD na na ma-maintain po ang family plan. So the same also applies for single or solo parent.
Mga tagapakinig, nagkaroon naman po tayo ng isang technical difficulty.
Sino na ba yung nun?
Si Attorney Ethel Angeles, siya po ang ongoing na nagle-lecture kanina, kaso nagkaroon ng interruption. So, maari ba natin ulit tawagin si Attorney Ethel Angeles para ipagpatuloy ang kanyang lecture?
Tuloy ko na po ang ating lecture. So, ang susunod ko naman pong tatalakayin ay ang support. So, ano po ba ang support? Support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation. So education include his schooling or training for some profession, trade, vocation, or even beyond the age of majority. Transportation shall include expenses in going to and from school or to and from place of work. Sino-sino po ba ang may obligasyon na magbigay ng suporta? Under Article 195, spouses, legitimate ascendants and descendants, parents and their legitimate or illegitimate children or grandchildren, legitimate brothers and sisters, whether full or half-blood. Source of support. For the support of spouses, the absolute community or the conjugal partnership shall be liable. For others obliged to give support, the separate property of the obligor shall be answerable. The amount of support, it is in proportion. So for the amount of support, proportion po siya kung saan po ang pangangailangan ng isang tao at yung kakayahan din po ng magbibigay. Ang tanong po, kung ang asawa ay tumigil ng pagbibigay sustento sa kanyang pamilya, ano po ba ang pwede nating mga remedies? Una po, mag-file po tayo ng criminal case or violation of Anti-Violence Against Women and Their Children Act of 2004, under Republic Act 9262, under the section Economic Abuse. A wife can file a legal case against her husband for failing to provide support to his family. It is punishable by prison correctional or jail. Ang pangalawa naman po, pwede tayong mag-file a case for petition for support. The guidelines on filing for a child support, una po, mag-engage po tayo ng legal services of a lawyer. Ang kaso po na ito ay pina-file sa regional trial courts or sa mga family courts po. Mali lang. The support is applicable to both legitimate and children. legitimate and illegitimate children, the woman parent will be the one to file the support of the child. Regardless of the marriage status, the father's support should be considered as compulsory. The revised rules of court provide for provisional remedy called support pendente lite. This is considered as provisional remedy or remedy sought by a party while an action for support is still pending before the courts. This is available to a plaintiff under Rule 61 of the Rules of Court. For seafarers naman po, ang Seafarers Allotment Policy. Unlike land-based OFWs, the POEA Standard Employment Contract mandates that the Filipino seafarer is required to make an allotment which shall be at least 80% of the seafarer's monthly basic salary payable once a month to his designated allotee in the Philippines. Tapos na po, maraming salamat po at mag-iingat po ang lahat.
Maraming salamat ulit, Attorney Ethel, sa inyong makabuluhang lecture patungkol sa adoption at support. At pasensya na ulit sa ating mga tagapakinig sa interruption ng lecture na nangyari kanina. At dahil po dyan, ang ating pangatlong speaker for today sa Batas Sibil at Marital ay walang iba kundi si Attorney Brin Ancheta-Mina. Siya po ang auditor ng Integrated Bar of the Philippines Nueva Ecija Chapter at ang founder ng Innovative Lawyering. Let's all welcome Attorney Brin Ancheta-Mina for his lecture.
Thank you, Attorney Mau, and good afternoon po sa ating lahat, and special mention po to Her Excellency our Ambassador Quintana, ma'am, and to our Consul General Angeles, sir. And it is indeed an honor to be one of the panelists today. And without further ado, here is my lecture. So one of the most usual questions na natatanggap po naming lawyers is that, Attorney, the law is clear. A married woman may only use one of the following na those enumerated in Article 370 of the new Civil Code. The article states that a married woman may use the following: number one, her maiden first name and surname and add her husband's surname. Number two, her maiden first name and husband's surname. Number three, husband's full name pero followed by a prefix. Example po yung Mrs. So the misconception po ay many of us na who has encountered this article are mistaken na a married woman may only use any of these three. So this is the question. Ito nga lang daw po, or is it limited to this enumeration? The law uses the word may. Yung may po is only permissive in nature. So a married woman has the option, but not the duty to use the surname of the husband. So kapag married ka po, pinakasal, you may still retain or use your maiden name even upon marriage, because when a woman marries, she does not change her name, but only her civil status from single to married. And as part of my lecture po, actually my lecture is partly civil and partly criminal, so I will proceed to adultery. So adultery po, first thing to take note is that it is a private crime. It is one of those crimes against chastity under the revised penal code. So being private in nature, it cannot be prosecuted or initiated by any other person aside from the private offended spouse. Under Article 333 of the Revised Penal Code, para po makonvict isang babae for the crime of adultery, she must be a married woman. And secondly, she unites on sexual intercourse with a man, not her husband. And on the side of the guy po having a sexual intercourse with the said married woman, dapat po there is a consummation of the actual intercourse. And secondly, he commits the act with the knowledge that the said woman is married. So before you can convict a man for adultery, yung importanteng phrase po dito is the knowledge. The man should know must be aware that the woman he is having a sexual intercourse with is a married woman. So it must likewise be noted that adultery po is always filed. Pag pumunta po sa court ito, laging meron pong dalawang akusado. So the usual question dito is, pwede po bang ma-acquit yung isa, pero maging guilty po, ma-convict yung the other accused? Pwede po yan. Yung adultery po is consummated, there is a joint physical act, but there may not be intent. Magkaiba po yan because intent is usually affected by a lot of factors. Example po, maaari pong yung ka-partner po is insane or mentally incapacitated. Maari din po na during the pendency of the case, one of the parties or the accused ay namatay, so the case pertaining to him would be dropped, but not necessarily na madadrop din po yung sa other accused. And also, let's discuss concubinage. Ito naman po ay a case where the married or the husband ay ng babae or kumabit po sa iba. So, the man must be married. And ito po yung mga punishable acts under the revised penal code. Number 1, keeping a mistress in the conjugal dwelling. Number 2, having sexual intercourse under scandalous circumstances. And number 3, cohabiting with her in any other place. Ano po ba yung mga yan? So, we enumerate. Yung sinasabi pong keeping mistress in the conjugal dwelling before one may be convicted of the crime of concubinage, kailangan po bang patunayan sa number 1 na may sexual intercourse? No more. The mere, basta dinala mo sa bahay nyo, sa conjugal dwelling, in your, sa tirahan po nyo bilang mag-asawa, it already consummates the crime of concubinage. So not necessary to prove na may sexual intercourse. Basta dinala mo doon and you are introducing her as your partner. Number 2, having sexual intercourse under scandalous circumstances. Can we give an illustration? So, eto po, what is being punishable here is actually yung the act of imprudently and wantonly offending the modesty or the sense of morality or decency of the public. So example po, they are living in a place na nagpapakilala po sila bilang husband and wife, and pinag-uusapan po sila, it gives rise to the impression na sila ay mag-partner. So it gives rise to criticism and general protest from the general public or the society. Number 3, cohabiting with her in any other place. So the key phrase po dito or the key word is cohabiting, cohabit. So yung cohabiting po entails some period of time. Hindi po ito pwedeng a matter of days. Usually po, cohabiting means usually months or even years. So the usual question po dito is, attorney, yung mga example, dinala po sa example, Sogo for a certain period of hours. May he be convicted of concubinage under letter C? Hindi po, because that does not mean na they are cohabiting in that place. Cohabiting entails a period of time. I'll go to recognition of foreign divorce. So the most pertinent law or provisions of law pertaining to this are the following. Article 26 of the new Civil Code, and yung recognition po in Rule 39 of the Rules of Court. So ito po yung laman ng Article 26 of the new Civil Code. Where a marriage between a Filipino citizen and a foreigner is validly celebrated, and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have the capacity to remarry under Philippine law. So madami pong conflicting jurisprudence or issuances before po etong case na Manalo. So the question po now is that, what if attorney, if the divorce obtained abroad was initiated by the Filipino spouse. Paano kung yung petitioner ay yung Filipino? May it still be validly recognized in the Philippines? Yes po. Considering the recent jurisprudence of Manalo, yung divorce decree obtained abroad, kahit na eto po yung petitioners may be validly recognized in the Philippines. Obtained by the foreign spouse, obtained jointly by the Filipino and foreign spouse, obtained solely. Eto po, kahit po yung petitioner is a Filipino citizen, pwede na pong i-recognize dito sa Pilipinas. What are the reasons kung bakit ganito yung recent jurisprudence? Sinabi po ng Supreme Court, verbal legis non est recidendum, or the words of the statute, there should be no departure. So ito po yung present ngayon. So until and unless the Congress changes the law, i-apply lang po natin. We only interpret. And to avoid po the absurd situation na yung Filipino spouse remains married to the alien spouse while the latter is free to marry. So pangit naman po yung may residual effect na yung foreign spouse hindi na po asawa yung Filipino citizen, pero yung Filipino spouse ay nakalink pa rin, kasal pa rin sa foreign spouse. So that the Manalo case resolves or settles this problem. Wala na po yung void na yon. And we also encounter po yung questions on kung may divorce law na daw po sa Pilipinas. Sad to say na wala pa pong divorce law sa Pilipinas. It remains a bill, and a bill is not yet a law. So a bill po is a mere proposal coming from Congress. It is an unpassed measure. So until and unless it becomes a law, wala pa pong divorce law in the Philippines. So that ends my lecture po. Thank you.
Maraming salamat ulit sa iyo, sa ating third lecturer sa Family Relations, kay Attorney Brin Mina. Thank you sa makabuluhang lecture mo patungkol sa adultery, concubinage, at recognition of foreign divorce. Meron po tayong mga natanggap na mga katanungan patungkol dito sa mga lectures na maaaring sagutin ng ating mga panelists at lecturers after lahat ng lectures po ngayong araw na ito. At Alan Jobo?